Welcome to Introduction to Jurisprudence. This is the fourth in a series of 5 videos where we are looking at some foundational concepts in jurisprudence, the philosophy of law. In this video we're going to look at economic analysis of law, otherwise known as the law and economics movement. Economic analysis of law is one of a range of socio-legal or social theories of law. These are approaches to understanding the nature of law, not by approaching law from within the discipline of law itself, but from the outside, considering perspectives on law from other disciplines such as psychology, cultural studies, or sociology. As Friedman explained in Law, Lawyers, and Popular Culture, by social theories of law, I mean theories of law whose premises deny, altogether or in large part, any notion of legal autonomy. That is, these theories try to explain legal phenomena by searching for causes and causal factors outside the legal system. They treat law as a dependent variable and assign a leading role in molding the shape of legal institutions and legal arrangements to systems or subsystems that society defines as non-legal. That is, as economic, social, cultural, or political. Social theories assume some sort of meaningful boundary, conceptual or analytical, between law and not law, between the legal and the social, but these theories also conceive of this boundary as wholly or largely porous, a kind of network or meshwork through which energy easily flows rather than as a tough, tight skin. In other words, these approaches insist that what defines law or gives law its character is not legal phenomena, but rather non-legal influences such as economics, psychology, sociology, culture, and politics. Specifically, economic analysis of law is the application of economic theories and principles to law and legal processes. It's based on the notion that law can and should be judged according to economic values. Now, by economics, in this context, we mean an approach to understanding behavior based on the assumption that individuals behave rationally, that is, that they have objectives and tend to choose the correct way of achieving them. Economics here is a way of thinking and a way of predicting human behavior. Here's an example of economic thinking that we all engage in. Why do we put locks on our front doors? Now you might say, well, to keep people out, of course, that we don't want to come into our homes. But the reality is that if somebody is determined to get into our home, a lock on the front door really isn't going to stop them. They can bash the door down or smash a window. The reason why we put locks on doors is because we want to make it difficult for a person who wants to break in to actually break in. We assume that a person who is looking to break into a house behaves rationally, that they assess the risk of being caught before deciding whether and which house to burgle. If a burglar sees our house and thinks that it's going to be harder to break into our house than, say, a neighbor's house, then they will rationally choose to break into the neighbor's house. So the real reason that we put locks on our doors is to make it more difficult for people to break into our home than to break into someone else's home. And we do this making certain assumptions about the way burglars behave rationally. So taking this approach to thinking about and predicting the behavior of others to the law, then we see that the legal system and the rules that we create within a legal system is really a set of incentives and disincentives designed to manipulate the ways in which people behave. Consider, for example, the rules regarding robbery. They are designed on face value to lead to the arrest and punishment of somebody who robs a bank, for example. But by thinking about these laws economically, we see them as disincentives. We assume that robbers are people who behave rationally and make a rational assessment of the risk of their behavior and the chance of them being caught. And so the amount of time, energy, and resources that we invest in the investigation of crimes and the penalties that we attach to crimes are designed and chosen based on certain assumptions about the way robbers behave. We assume that they will make a rational assessment of the risk of being caught and the penalty that will apply to them if they are caught, and rationally choose not to engage in robbery. If the risk of them being caught is too low or the penalty is too low, then they might rationally decide that it's worth the risk. But we cannot make the penalty too high. If, for example, the penalty for robbing a shop was automatically the maximum penalty of, say, life imprisonment, and there is no additional penalty that attaches to, say, a robber who engages in violence or even kills a person while engaging in a robbery, then there is no incentive for the robber to refrain from violence or refrain from killing someone when they engage in a robbery. And in fact, it might be the rational choice for the robber to kill any victim in order to minimize the chances of being caught at a later stage. And so the penalty for engaging in robbery without violence must be less than the maximum penalty. And all of this is based on assumptions about robbers behaving rationally. This is economic thinking. Similarly, civil law is a set of incentives and disincentives intended to influence the ways in which people behave. The law of negligence, for example, is typically thought of as a mechanism for providing some sort of compensation or other remedy to people who are injured or harmed as a result of someone else's carelessness. But thinking about the law of negligence in economic terms, we see that it is a set of rules designed to incentivize careful behavior. We assume that members of the community behave rationally, plan their actions carefully, and if they are aware of the consequences of behaving negligently, i.e., that they could be sued by the victim of their carelessness and forced to compensate them, then they will choose rationally to behave carefully and avoid engaging in negligent behavior. According to economic analysis of law, the ideal of law, therefore, is not justice or fairness, but efficiency. A legal rule or process is said to be efficient if the overall economic benefits of the rule or process exceed the overall economic costs. The objectives of economic analysis of law include the assessment of particular legal rules, so deciding whether or not particular statutory rules or case law decisions are economically efficient, and guiding legislators and judges in the making of new rules, or at least in choosing between various alternatives. So, for example, a judge who has to make a decision in a trial might weigh up the economic costs of the various possible decisions and choose the decision that is most economically efficient. Now, economic analysis of law is one that is gaining some traction amongst legal scholars and legal practitioners, including members of the judiciary. According to Richard Posner, many areas of the law, especially but not only the great common law fields of property, torts, crime, and contracts, bear the stamp of economic reasoning. Granted, few judicial opinions contain explicit references to economic concepts, but often the true grounds of legal decision are concealed by the characteristic rhetoric of opinions. Indeed, legal education consists primarily of learning to dig beneath the rhetorical surface to find those grounds, many of which turn out to have an economic character.